Today I am honored to have with me Judge from Kenya, Justice Nicholas Ombija, who is visiting the U.S. on a seminar. And he's been very gracious to accord me this time to speak with him and pick his mind a little bit. So I hope you enjoy the conversation, and we'll try and give you as much information as we possibly can. Judge, thank you very much for being here. Now, when I've heard so much about you, but I've not met you before. I think the first thing that came to my mind was, what makes you? What is your essence? What makes Judge Nicholas Ombija?
I am a self-made person. I started my legal career in 1980 when I was admitted as an advocate to the High Court of Kenya. And for the next 22 years, I practiced law in Kenya, perhaps at one of the biggest firms in Western Kenya. And they were practicing under the name and style of Ombija and Company. And the year 2001, I decided to change my career when I was offered the job of being a judge of the High Court.
Mm-hmm.
All along, since I was young, I had an ambition of being a person in the legal profession, and it is not an accident that I happen to be in that profession. It is something I'd thought about as early as when I was in class 5.
Wow, that was very early.
Yes.
Yeah.
And I think one of the things that drove me to that is that I thought advocates
mm-hmm.
or lawyers have a very special, they have a very special space in society.
Mm-hmm.
For example, if you take the American War of Independence,
mm-hmm.
And in many other countries, normally freedom is championed by lawyers. And it gave me the drive.
Was there
and
somebody?
The vision.
Yeah. Was there somebody at that age that you looked up to, that gave you that drive, at least to look up and say, I want to be like this person?
I was reading about Abraham Lincoln.
Mm-hmm.
I was reading about Nelson Mandela. I was reading about Robert Mugabe. These people are all lawyers.
Mm-hmm.
And the contribution they made to the freedom movements in their various countries, I think gave me an impression that legal profession, legal mind is quite important in the pursuit of justice. And I thought I should be part of that process.
And so you find yourself going through the University of Nairobi.
I find myself going through the University of Nairobi,
mm-hmm.
being admitted as an advocate, practicing law,
mm-hmm.
successfully practicing law. And then I think I caught the eye of the Chief Justice, the then Chief Justice. And he asked me if I could offer myself for judgeship.
Mm-hmm.
And I thought after working for over 2 decades as an advocate, it was time for me to go to the other side.
Now, how has that transition been? What's the difference that you see between the 22 years that you practice as a lawyer, as an advocate, defending people in court, in your own practice, and now having to transition into being a judge on the other side of the fence?
Of the divide.
Yes.
Well,
How has that been
the 22 years gave me the grounding, the proper grounding upon which now I am working, because you need to be an astute lawyer to understand particularly how you can sit in the bench and decide cases that affect the lives of many people. And you have to have a grounding in law, proper grounding in law. So those 22 years, I think, gave me that grounding, which is essential. Normally, my own view of things is that a good practitioner normally ends up as a judge.
What are the challenges? I would imagine that the challenges are a little different. As a practicing lawyer, you're defending people. You're on the other side, trying to convince the judge that this person is not guilty of the crimes that they've been charged for, and I would imagine that there's a difference. There are different challenges that you face when you're defending somebody versus now that you're a judge sitting back there and listening to the evidence and making an informed decision on how you're going to rule the case. What are the difference in challenges?
You see, as an advocate, you only look at your client's case, which means you look at things from the prism of your client interest. But as a judge, you have to look both ways. You have to look at the prosecution side, you have to look at the defense side, and then you have now to weigh the evidence presented by both of them. But an advocate's business is just to throw in his client's a view of the matter, and you leave it to the judge. So the biggest challenge is that you have to balance. As a judge, you have to balance both sides and come with an answer, which is a judgment in this respect, which is sound.
Now, Kenya is a young democracy, and as a young democracy, it has its own challenges in terms of governance, in terms of the law. So I guess what I'm getting at is now, as an advocate, you have the freedom of no outside influence. As a judge, people are looking at you from almost a national perspective, how you make the judgment, the rulings that you make, and the nuances of the political atmosphere itself. How do you walk that line? How do you find yourself walking that line?
Balancing between the political
side and expectation, being that Kenya being a young democracy, there's still a lot of things that are not very straight, clear-cut. How do you walk that thin line?
In my own way of looking at things, I don't look at the political angle of things when I'm making a decision. I look at the evidence available, and then I marry the evidence to the law, and then I come with a conclusion, which is a judgment. I never look at the political angle, the political consequences, to me, it did not really matter. It did not matter.
Mm-hmm.
Because if you have to do that, then you will be doing injustice. You cannot imprison somebody because the politics or the times demand that you do so.
Mm-hmm.
I will make a judgment depending on the evidence which has been presented before me by both sides. And that is all.
Now, you talked about, being interested in law much earlier and reading about the American justice system. The American justice system is where the judge is almost kind of somebody who directs the proceeding, but the ultimate finding, whether guilty or not guilty, lies with the jury. The Kenya system is not a jury system. How do you compare those two, and do you see any shortfalls in any of those two?
In the criminal jurisdiction of the Kenyan High Court, until very recently,
Mm-hmm.
there was the criminal proceedings were conducted with assistance of assessors,
Mm-hmm.
and that is the equivalent of a jury here. Not that assessors would have the final word, but they would assist the court in matters maybe dealing with factual matters, as not legal matters. But at the end of the day, it is the judge's decision that carried the day.
Right.
Yes.
Okay.
So until very recently, I think 5 or so years ago, I mean, we used to have some kind of jury system in the criminal jurisdiction only, not in the civil.
Okay.
Yes.
You have, from how you look at the law, recently, I think you've been looked at from the judge point of view as a very controversial. You've presided over some cases that are seen as very controversial. The most being that has really caught fire is your recent judgment that the president of Sudan, Omar al-Bashir, should be arrested if he set foot in Kenya, because Kenya is a signatory to the ICC. And being a signatory to ICC, the International Criminal Court, and being part of the Rome, again, the Rome Statute, that you have jurisdiction to make that ruling that Kenya, if al-Bashir comes to Kenya, he should be arrested. That has caused a lot of stir. I remember reading in the local papers that immediately after that ruling, the government had to send some high delegation to Sudan to kind of smoothen things. Now, making that kind of I'm sure that the law is on your side, but that was a very landmark. Could you elaborate on that? What is the whole circumstance surrounding that?
Patrick, the Omar Bashir case.
Mm-hmm.
I think one of the things that some people may not understand is that an application was made before me by ICJ, the Kenyan chapter, and all they required was an order to implement the ICC warrant The warrant was issued by the ICC, and Kenya was merely implementing that warrant. So when the matter came to me, my business was to look at the propriety of that application, whether it met the threshold of the international law. And the issues before me in that application were very, very simple. One, did ICJ Kenya have the locus standi to bring the application? In other words, was it a busybody? And two, Kenya, being a signatory to the ICC, was it entitled under the law to cooperate with the court in having that president arrested? After going through various authorities presented before me, and some of them known to me, and covered quite a bit of ground, I looked at how UK gives jurisdiction, locus, Australia, Germany, Canada, and several others. And locus standi in those countries has been very wide. It has been interpreted very widely. Then I looked at the memorandum, the objectives and memorandum of ICJ, and I found out that one of their mandates is to maintain the rule of law. And I thought, that being part and the most essential part of their mandate, this was an issue of maintenance of the rule of law. More particularly because the Kenya government had neglected their duty under international law. They are obliged under the Rome Statute
and here,
to cooperate with the court, arrest Bashir and hand him over. But then they failed. Instead, they invited him during the promulgation of the Constitution.
right,
And in violation of international law. And here is a body who has mandate to maintain the rule of law. And they are saying Kenya has violated its obligations. Please give us the okay to implement.
Now, does the new constitution give the courts more strength to come up, to make such rulings? Would you have made these same rulings, let's say, for example, under the older constitution?
I could have done that. You see, the constitution is, the constitution and any other law, you have to breathe life into it. And normally, judges are very innovative people. Occasionally, you find the judge has made law himself, because he could say, I could say that the spirit and letter of this constitution demands that this is the way forward, and I make it in the form of a judgment. That is what we call judge-made law. A judge can breathe life into the constitution, into any law. Because the law does not spell out everything. It only gives you indication of what direction and how far you can go. But it's upon you to understand that you can breathe life into that constitution, into that law, by looking at the spirit of that law, the spirit of that constitution. So under the old constitution and even the new one, I mean, the spirit demands that you do justice. The spirit demands that if you are a signatory to an international treaty, then you have to comply with it. I don't think the new constitution has given anything more than the old constitution had done. In other respects, yes, because we are now more or less a federal government,
Right.
with each county looking after itself. But otherwise, the spirit of the letter and the letter of the law is still the same, both under the old constitution and the new one. So it's upon an individual judge to find that spirit. It is always there,
Okay.
and it is upon you to find out how you can use it in the wider interest of justice.
Now, what is the possibility
Yes.
that your ruling would be carried out if, for example, the executive goes ahead and invites Bashir and he comes into Kenya? What are the chances that that would be carried out? The ruling would be carried out.
The ruling I gave was that the ICJ Kenya had the local standby to bring the application, and I also gave them the warrant.
Mm-hmm.
And I said in the judgment that if they do not have the mandate to arrest Bashir, then they could apply for orders of mandamus, a prerogative order of mandamus, compelling the minister in charge of state security
To do it.
to do it. So it will be upon the minister to refuse to do it, in which case he will be in contempt of court. And he will be dealt with under the law of contempt like anybody else, because nobody is above the law.
And that was what my next question was going to
Yes.
be. What is the political will? Is there a political will to actually go by the letter of the law? Because these are the two opposing things. The minister in charge of internal security decides that they're not going to arrest Bashir and turn him over to ICC, in which case he's in contempt of court. How do you maneuver that? And of course, yes, he's not above the law, and that is very clearly in law. How is that resolved?
No, you see, if we are dealing with the contempt, the only thing that will have to happen is that the person bringing the application for contempt, whether it is ICJ Kenya or anybody else, will have to strictly adhere to that law, make a proper application, follow the legal provisions. Because sometimes contempt applications are defeated if you do not go by the letter,
Right.
yes, of the law. If you fail to do something in the application which is mandatory, because an application for contempt is such a serious thing that you have to follow the law to the letter. Otherwise, a very small thing can make the application fail. But if it is a proper application supported by proper evidence, we shall give an order for contempt. And as I said earlier, the minister is not above the law. Nobody is above the law.
But that is true, and that
Yes.
may be so.
Yes.
But we have to go back in history, in the very recent Kenya history, where big cases have come up. The Goldberg case, the Mays case, where commissions after commissions have been set up, but and people have been pointed out to have been, or there's reasonable evidence for them to appear and be prosecuted. And it seems that the courts get bogged down by application after application. Now, in this case, assuming that this happens, and the minister is in contempt, and the courts are bogged down by what has happened before, application after application, the minister ceases to be a minister. Things in the past have seemed just to fizzle out after a while. And that's where the will of the government, of the people, come in. How does the law deal with that?
You see, Patrick, what is happening is that a judge does not look for people in the street and say, bring the application, I want to prosecute these people. People are brought to us. Mm-hmm. There's a channel through which matters come to court. And if they come to court and the application is listed before me, then I deal with it.
Okay.
You are talking about these other cases which have been bogged up. They have not been brought before court sometimes. You find that somebody has to make an application. Somebody has to file a case. Because there is an arm of government that does that, the prosecution side. If the prosecution fails in its duty, how is the court supposed to move? They cannot go and say, bring that case before me.
Right.
I want to deal with it today. The judge cannot act like that. You wait until the matter is before you. It is brought through a system.
Now,
so if the prosecution wing of the government fails, then, I have no answer for that.
Okay.
We will just say he has failed.
Okay.
But if the matter is brought before me as a judge, I will deal with it according to the law.
Okay.
We will not flinch.
Now, in our conversation earlier on, one of the questions that I was also curious about, here in the United States, people are very aware of the law. If you went into a McDonald's or into a restaurant or any public place, and let's say you slip, the floor is wet and you slip and you fall, you know that you can sue that the management or whatever institution it is. The Kenyan Constitution says that the people have the power. The power rests with the people. How has, since the passing of the new Constitution, has there been any way to educate people, the common person, the least of the citizen, on what their rights are, how far they can go with the law, that they are actually protected by the law and they'll actually get a fair trial if they do so? And we have to consider the fact that bringing a case is very expensive. You have to have a lawyer, and most people can't afford a lawyer. And therefore, these are some things that may discourage a common person from pursuing to have their grievances,
But the new constitution, I'm not sure whether you are conversant with it. I think we have one of the best constitutions in the world today.
Okay.
Yes, because among other things, you don't need money to file a case in the Supreme Court.
Okay.
And
but you need a lawyer.
You don't need a lawyer.
Okay.
You don't need a lawyer.
How so?
There are many people who come to court and they pursue their cases very successfully without a lawyer. I mean, it's very easy, because what you do, when you file your case, now the matter rests with the court. Sometimes, if a person comes to court and he does not have a lawyer, then the court must look at his papers very critically. Sometimes you find that the court is very soft on a litigant without a lawyer.
Okay.
Yes, they're very soft. So all these technical issues that could make a case fail, you can easily gloss over them and look at the substance of the case without technicalities. But lawyers actually lawyers are the ones that bog down the cases because of technicalities of procedure. Under the new constitution, those technical procedures, it is now under the constitution that cases will be done without regard to technicalities of procedure. You look at the substance. That is what the constitution now says. And two, you're underrating Kenyans. I think you left Kenya a long time ago. Kenyans are very clever people. They know their rights so much. There's so much litigation going on in Kenya that it is not the Kenya that used to know. And I pity whoever is going to be a president and whoever is going to be in power, whatever, whether you are a judge or whatever, because people have become so litigious. They know their rights so well that you can't take people for granted any longer. Yes. You have to be very careful when you handle Kenyans at the moment. Even as a judge, you must be very careful. They know they can't take you on. They will not flinch at anything.
But the other side of it is the speediness of
disposal of cases?
Disposal of cases.
Oh, yes. You see, what you do not understand now, or you may not be aware of, is that we are increasing the number of judges already. There was a limit under the Constitution